We'll go ahead and get this meeting started. We have one hearing today, so it shouldn't take long. That's all dependent on how long Ed wants to talk and, well, then the subsequent questions thereafter. So we're going to open the hearing on Senate Bill 217 and ask Natalie to give us an overview.
Thank you, Mr. Chairman. Senate Bill 217 includes the conduct of utilizing an electronic tracking system or acquiring the tracking information to determine the targeted person's location, movement, or travel patterns in a variety of statutes. So it'll be in the crime of stalking when done as part of an unlawful course of conduct, and authorizing orders to prohibit that conduct under the Kansas Family Law Code, and also a few sections in the revised Kansas Code for the Care of Children, the Protection from Abuse Act, and the Protection from Stalking, Sexual Assault, or Human Trafficking Act. Section 1 amends KSA 215427, that's the crime of stalking. Current law there makes it unlawful for a person to recklessly engage in a course of conduct targeted at a specific person, which would cause a reasonable person in the circumstances to fear for such person's safety or the safety of a member of their immediate family, or to engage in a course of conduct targeted at a specific person with knowledge that the course of conduct will place that person in fear for their safety or the safety of a member of their immediate family. Course of conduct there means 2 or more acts over a period of time, however short, which evidence continuity of purpose. The definition there lists several examples of what can make up those 2 acts, and this bill adds utilizing electronic tracking systems or acquiring their tracking information to determine that targeted person's location, movement, or travel patterns. Section 2 was added by the Senate committee. It amends KSA 232244. That's a section in the Kansas Parentage Act related to the enforcement of court orders. Current law there provides that the court can make and enforce orders that restrain parties from molesting or interfering with the privacy rights of each other. And this bill would clarify that those orders can include restraining the parties from utilizing those electronic tracking systems or acquiring their tracking information. Section 3 amends KSA 232707. That's the Family Law Code statute that concerns permissible orders. Current law there also provides that after the filing of a petition for divorce, annulment, or separate maintenance, and during the pendency of that action until entry of final judgment, the judge assigned can make a list of certain orders. Subsection A1 there provides that the court can jointly restrain the parties with regard to disposition of the property, and provide for the use, occupancy, management, and control of that property. This bill adds that that order can also include utilizing those electronic tracking systems or acquiring tracking information to determine the other person's location, movement, or travel patterns. Under subsection A2 there, current law allows the court to restrain parties again from molesting or interfering in their privacy rights, and the Senate committee did add an amendment here to clarify that those orders can also include restraining those parties from utilizing this electronic tracking information. Sections 4, 5, and 6 amend statutes in the Kansas Code for Care of Children. 4 amends 382243, which concerns temporary orders. 5 amends 382244. That's the statute on informal supervision. And 6 amends KSA 382255. That's the statute about authorized disposition and custody of children. Current law in all of these sections provide that the court can enter a restraining order against the perpetrator of physical, sexual, mental, or emotional abuse of a child. Right now, those orders can prohibit that person from residing in the child's home, visiting, contacting, harassing, or intimidating the child, or attempting to visit, contact, harass, or intimidate the child or other family members. This bill would also include in those orders that they can restrain that person from utilizing tracking information to track their whereabouts and movement patterns. Section 7 amends KSA 603107. That's related to orders in the Protection from Abuse Act. Current law there authorizes the court to grant orders restraining the defendant from abusing, molesting, or interfering with the privacy rights of the plaintiff or minor children of the parties. This bill would add that those orders can include a prohibition on utilizing those tracking devices to track their movements. And then finally, Section 8 amends KSA 6031 A06. That's related to orders issued under the Protection from Stalking, Sexual Assault, or Human Trafficking Act. Current law there, again, similar in protection from abuse, authorizes the court to grant orders restraining the defendant from following, harassing, telephoning, contacting, or otherwise communicating with the victim, and restraining that defendant from abusing, molesting, or interfering with the privacy rights of the victim. And again, this bill adds a new subsection H to provide that harassing or interfering with the privacy includes utilizing those electronic tracking systems. And I can take any questions.
All right, committee, Representative Eric Smith.
Thank you, Mr. Chair. So I'm going through this, and I'm pretty sure that it would include any app that you'd have on your phone or other electronic device that you can enable location sharing on. So if I surreptitiously get into somebody's phone, create a location sharing connection to my phone, this would cover that. Would it not? Under the idea that electronic tracking system or acquiring tracking information to determine their location.
Mr. Chairman, yes, I think that's the idea. You know, me and my husband are sharing, using the Find My Friends, we're sharing our location services. We end up getting divorced and there's restraining orders put in place. Those orders could prohibit him from using that information. You know, we would have to disassociate our location services to make sure that the other can't track the movement patterns.
Right. Thank you.
Certainly. But what if I wanted to just drop a little tracker tile in the back of his pickup truck and see what he's doing?
Mr. Chairman, I think that also would fall under something that by adding this language, the court could enter orders in those circumstances to prohibit you from doing that.
But they would have to enter an order, and that's assuming that there's some other criminal act or protection or something involved.
Yeah, so the language that we're talking about here, it's being added to the crime of stalking. So those things could be used in that circumstance. It's being added to protection from abuse and protection from stalking orders. So if you get a PFA, it's added in certain family law code sections, so divorce situations, and also Parentage Act. So for example, if I were abusing my children and there was a restraining order where I can't see my children, if I were to try to put a little tile in their book bag or something like that, that would be included in something that I cannot do under that restraining order.
Okay, thank you very much. Representative Slingersieben.
I think the question is answered by the bill after reading it, but I just want to make sure. So I have a friend, for example, whose spouse had a psychotic episode and left the house and drove a great distance, and the family was worried and wanted to know where she was. She'd left her phone at home, and the phone was pinging her watch or her key fob, one of the two, and so they were able to track her for a long distance so they could send somebody after, so that she would be okay. So the question here is a family member getting in trouble for trying to keep another family member safe? I assume the language rules that out, but I just want to be clear that that scenario doesn't fall under this.
Mr. Chairman, that scenario would not fall under it unless that family member were already subject to a restraining order or some other type of court order restraining that type of activity.
Thank you. Thank you, Mr. Chair.
Further questions, committee? Seeing none, thank you, Natalie. We have one single proponent, Ed Klump, Legislative Liaison, Kansas Sheriff's Association, Kansas Association Chiefs of Police, Kansas Peace Officers Association. Welcome, Ed.
Thank you, Mr. Chairman. I won't repeat that. I am Ed Club with those associations. Hopefully my testimony will be shorter than Natalie's review of the bill. Because all that's left here is really to explain why we're here and why we proposed this bill. Over the years, we've encountering more and more of these cases where people are using like the Apple AirTags and things like that, even getting into the cell phones and establishing them to transmit location. We've had several cases where after repeated violations, which is always for the stalking law, for example, or for the violating protection orders, that they end up in homicides or serious battery cases. serious injuries to the victim. And so we started looking at this about a year ago, and one of the places we looked was the National Council on State Legislators, and they have a document on this where they've looked at this. And in that document, it reflected that at the end of last year, there were 26 states in the District of Columbia that had addressed this issue in some manner in their state laws. About half of those did it the way we're proposing to do it here. The other half are kind of a mixed bag. There's probably about a half a dozen that just said it's illegal to use a tracking device unknowingly on anybody. We thought that was kind of a slippery slope. There's too many situations in the corporate world and things like that where people want to track their employee, their truck, their equipment, whatever. And so we thought this was the narrowest way to do it and achieve what we're really after. So this bill really has what I call two major sections. One is Section 1, and Section 2 is every other section in the bill. Section 1 is the one that addresses the stalking law. And in the current stalking law, you'll see that there's 7 conditions that are used to determine if there's what's called course of conduct that leads to the stalking charge. And you have to meet at least 2 of those to have a stalking violation. And there also has to be a factor of fear or intimidation to have a stalking violation. So that's why it is narrow enough not to include the situations like you talked about with family. And that's certainly one of the things we thought about as we crafted this, is we didn't want to make it that expansive. And so that's why that was that way. So Natalie explained all the different sections of the bill, and what we tried to do is we wanted to cover stalking because that was one of the major areas that is used when a person is sometimes in these domestic cases or other situations and they don't have a protection order yet. But at the same time, we wanted to be sure we covered all the different types of restraining and protection orders. And that's what made this bill voluminous, is because we had to go into all those laws. And there's, as you can see, there's a lot of different laws allowing protection or restraining orders. So we tried to be all inclusive of the different ways that could play out. The language that we chose not sure exactly what the language is, but it has to do with utilizing the tracking system or device or acquiring the tracking data in order to do these violations. And we added that last because we didn't want Joe to just have his friend Bob drop the air tag in the purse, and then he gives Joe the data, and then Joe's off the hook because he didn't use the tracking device. And so that language is intended to cover that kind of a situation, which we have run into. So that's the crux of the bill. It is intended to cover any type of device that will transmit or reveal location data, whether it be through a cell phone app or a device like an independent device. And not just air tags, but we also occasionally find actual vehicle tracking devices stuck underneath a car and things like that in these cases. So it's meant to encompass any kind of a tracking system that provides that data. We believe this is a very important change to the law to protect victims. And I want to stress that's what this bill is about. This bill is all about victims. It's not about us. It's not about law enforcement. It'll help us protect victims, but it's really all about victims. And I'll note that there is no change to sentencing provisions. There's no new crime committed other than we just clarify that these acts of using these tracking devices is part of the prohibited following or intimidating or all those words that are used in the various statutes. And with that, Mr. Chairman, I'll stand for questions.
All right, thank you, Ed. Representative Eric Smith.
Thank you, Mr. Chair. I think this is an extremely important bill based on the experience that we're having, especially now. I think it's a growing problem. Couple of things. I'm divorced and I have the kids every other weekend. My wife or ex-wife has a protection order against me. But when my son shows up, he's got his phone with him, and I know he's got Life 360. and I know he knows where she's at because it's right there on his phone. And I access that through his phone. Am I acquiring tracking information that way?
I would say you probably are. I think whether you're in trouble with it or not is whether you violate the order with those terms of following, intimidating, and things like that. Because remember, all we're doing is saying that those conditions include using the tracking device to follow or those things. So I think if you just access it and you don't do anything with it, probably you're not in violation of the order. I mean, it would depend, I think, on how the order was worded. If they specifically said you can't track somebody with a tracking device or something like that, then that might be different. But then again, you know, I think it's going to be in how you use it. And I think that's going to be flushed out too with.
And I think that's important because if I take a report from a gal who's a subject of that, and she says, well, I know he got the information off my son's phone, and isn't that against the law? You know, that kind of thing. That's where we're going to run into that.
And I would say if that person did that and using that data then violated the order by following or by intimidating or all those other words that are used, then it appears to me that would be covered. But if they didn't do those things, then I don't think they would be in violation of the order. And you certainly wouldn't be in violation of stalking unless you did more than that to create that course of conduct. And then you also have to have the fear, intimidation, and all that on top of that.
Well, and on that, you have to have the fear and intimidation, all that. When it's done surreptitiously, they may not be aware that it's occurring. So is that an element that you can get around, or do you have to have that, like assault? The individual doesn't know they're sneaking up behind him with a board. You can't charge them with ag assault.
Well, the way I see the stalking law is that you have to have that to have a stalking violation. But when you're talking about protection orders, if you use that data to follow that person, or whether you make contact with them or they're aware of that or not, if you're engaged in the conduct that's prohibited in the order and you're using the tracking device to do that, then you're going to be in trouble. Now, you're going to be in trouble anyway, even if you don't use tracking device and you're doing those things. So all this is saying is using the tracking device is included in the prohibited conduct to permit you to do these other violations of following.
You know, Ed, I'm thinking about the idea where I'm doing a search warrant on a guy's phone for another reason. I come across this tracking information. Individual doesn't know they're being tracked, and I find out they have a protection order. Now, they have no fear or intimidation involved. I found this information. Will this law, you know, cover that situation?
Again, I think that's going to depend on the wording in the protection order or the restraining order. If it specifically says you will not use a tracking device, you know, related to the person that's protected, then I think you've got a violation.
Yeah, I agree with you. I don't think it's
But if you never used it to follow and you're just relying on those general terms in an order that says you can't follow or intimidate this person, then you probably don't. But I think, you know, so you get down in those weeds and it's always so fact specific. And in the end, you have to look at that totality of all those facts on whether it's a violation or not.
Absolutely. Thank you.
Additional questions, committee?
All right.
Thank you very much, Ed. I see no opponent or neutral testimony unless Willie, Jeff, any of you guys got anything to add? Okay. All right. Well, we're happy to have you. Thanks for joining us. 100%. Definitely wins the award for the most visited conferee for the year, no doubt. All right, committee, we'll go ahead and close the hearing on Senate Bill 217. We will not meet tomorrow, and you saw the updated agenda for next week. We will not meet Monday. On Tuesday, we will work the 4 bills that we've heard this week, so be prepared with any amendments. And I'm just about positive we'll have an amendment on every single one of them. So 'tis the time of year. So anyway, thank you. We'll be adjourned. Have a great weekend.